night's networking dinner. The energy we witnessed were truly inspiring. As we embark on day 2 of the 25th IIPLA 2025 Dubai, let's take a quick moment to reflect on the incredible insights we gained yesterday. From navigating IP protection complexities to exploring litigation trends and cutting edge technological impacts, we have already set a high bar for discussions. So let's start today's session. And the name of the session is Future Trends in IP, Metaverse, Virtual Worlds, and Emerging Litigation Challenges. This session will be moderated by Prayank Khandelwal, founding partner, Photon Legal India, Avinav Banerjee, lead intellectual property analyst, Airbus India, Olaf, managing partner, Page White and Ferrer, Germany, Sandjar Muminov, I'm so sorry, President, Sandjar Group, UAE. Please welcome on the stage.
Hello, good morning, everybody. Thanks for joining us back again. It's a great to start the day with an amazing panel we have, and the topic is also pretty interesting, which is about future trends in IP. Last night, before closing in, we discussed how the IP ecosystem would look like in the next 5 years. And in the morning today, we will be talking about how the future uh, holds when it comes to IP and different trends. So we're talking about metaverse, virtual worlds, and emerging litigation challenges. I'm very surprised to know some of the interesting way you can have your company registered in UAE, or uh, even your banks registered in UAE in the virtual world without much capital and regulatory approvals. So would go deep into all of these points and understand how metaverse, digital twin, AI, and Internet of Things is adding value to everything, whatever we do, and how things will be impacted in the future. We have a pretty interesting setup for this discussion. Olaf and Avinav would be presenting some of their insights, while Sanjdar and I would continue to ask them questions and take the discussions ahead. So without further ado, I would request Olaf to share some of the interesting insights on the UPC side and his learnings from a couple of case laws which he has prepared, so that we get to know more about how the EP practice has evolved over a period of time. And after that, Avinav would share how Airbus is using all these future technologies in their day-to-day operations and how it's shaping the future. And then we move into the panel discussions afterwards. All right, so Olaf, if you can share your insights. Thank you.
Good morning, ladies and gentlemen. I'm happy to speak here at this interesting conference. My topic is more about emerging litigation opportunities, so I'm not directly covering the metaverse issue, but later in the discussion maybe. So, as you might heard about, we have a radical shake-up in Europe, because so far as you know, the European patent is a bundle of national patents that is examined together, but then it falls apart into national patents and had to be litigated nationally at different courts. So you had the problem that you had different decisions, often in Germany, UK, France. And now with the establishment of the Unified Patent Court 1.5 years ago, we have the option to have one civil court. That's a very new situation. One civil court where you can litigate patents, and the territory of the decision covers 18 EU countries. It's of course, it's limited to the EU, so countries as Switzerland do not participate here. So, what's it all about? As I said, just the legal background are different regulations, 2 EU regulations, because we also have a patent with unitary effect now. This is one patent package. The patent with unitary effect is actually no different difference in examination. It still goes via the EPO, but at the end, when you have the decision of grant, you can now say, I want to have a unitary patent. That means you have a patent that covers the areas of all these 18 member states. This is new, but examination is the same. Then we have the agreement on the Unified Patent Court, and we have the rules of procedure. So there are own rules of procedure for this court. This is the legal background. Now what has changed now? Meanwhile, we have different routes. So the tools available for patent protection in Europe has increased. So we still have the national patent office. So if you have an innovation, you can go via the national patent offices. You can choose Italy, you can choose Germany, and get your national patent. But now also you have the EPO route with 2 different branches. You have the normal branch that you get your bundle patent. So this is, for example, you designate the countries, and at the end you select 3, 4, 5 countries where you want to have protection. But now you have also a new kind, we can call it a new designation, which says, I want to have a European patent with unitary effect. So at present, the situation is about 75% will be bundle patents after grant, and about 25% of the patents can be unitary patents. That's the situation currently, so that you have an idea how many people select this option. Of course, what is critical, the decision for select the unitary effect is the annual fees, the renewal fees, because of course they are higher, and there is, you can say, starting from 3 or more validation, it makes sense from a cost view to have the unitary effect. So just a comparison of the territories that we have. These are the territories of the EPC. You see there are a lot of countries, even non-European countries are available. And this still remains the same with the bundle patent, but now what is new is we have now the unitary patent. Is one validation, is one patent, but covers several UPC member states, all the 18. There is a cost benefit, as I said, if you have more than, or at least, say, 4 UPC member states that you have so far designated. But it must be member states, of course. If you designated the UK, this does not count because you still have to designate the UK. UK is not part of the EU, so if you want to have patent protection in the UK, you still have to go the conventional way via the bundle patent. So they can coexist. You can have bundled patent countries, and you can have the unitary patent effect. It's both available. So here you see the 18 states that we meanwhile have. Just roughly to see that, of course, it's not whole Europe, but it's a lot of the important states are included. Here are the 18 member states we have. Non-EU countries are not available. This is like Switzerland, Liechtenstein, Norway, and other non-EU states. And some EU countries did not participate. That's Spain, Croatia, or Poland. Might change in the future, but it's not in sight at present. So how is the court system built up? We have 2 instances. We have a first instance with local and regional chambers, or divisions, sorry, and we have a court of appeal in Luxembourg. That's a situation, and question, there can be a referral to the ECJ if there is a question about EU law. So it's all bound to the EU system and legal system. And that's, as I said, that's why we don't have non-EU member states included. And we have central divisions. This should have been London, but as UK, after Brexit, we had to skip London, and now we have Milan as the 3rd central division. Paris, Munich, Milan. What is the criteria? The criteria is the IPC class. So we can say if you have a case for the central division and it's about electronics, then you will end up at Paris. Munich will be more the mechanical side and Milan the chemical side. It's not exactly that division, but roughly speaking. And the second instance, the Court of Appeal, will be handling all these things. What does it mean? LQ, that's a legal qualified judge and one technical qualified judge at the central division. In the local regional division, we have 3 legal qualified judges and 1 optional technical judges. That's also one difference we can recognize, because as I will say, we have these local and regional divisions, there is no bifurcation, so there's no separation of validity and infringement. It's judged together, it's decided together in one court as usual, but contrary to our German situation. And that means you will have 3 legal judges decide about technical issues. That's typical in other countries, but for us Germans, that's a special situation because we know we have the patent court where 3 technical judges decide. So this is a different to be considered, but for most European countries, it's typical as it was before, so no special issue. Here you can see where the divisions are located. The Court of Appeal is in Luxembourg. We have also an arbitration center. We have a training center in Budapest for the judges. And you see the courts of first instance and the one Court of Appeal here. You see it's many different countries. A regional chamber is Scandinavian, and this has also separate branches there in different countries. Just to give you an idea, so there is a lot, as you can imagine, there are a lot of options for forum shopping here. Interesting is how can you use these? What is the jurisdiction? So the central division is normally used for validity. If you have a revocation action, you will end up at the center and the central division, if it's an isolated revocation action. But if there is the place of infringement or the seat of the defendant is not in a UPC member state, you can also do the infringement action at the central division. And in the local divisions, if you have an infringement action, the defendant can file a counterclaim for revocation, and then the division can decide whether to handle both, whether to give it up, give the validity case to the central division, so then we would have a bifurcation, but practically this does not happen. Or we can refer even the entire case to the central division, which is also very seldom. So as a patentee, you have the option either to use the local division, that's the normal thing, if there is infringement in the specific member state where you want to have the action handled. Normally in internet-based infringement things, it's not that difficult to get an infringement place there where you want. Or you can choose, if you sue an American company, you can use the central division because it's not an UPC member state. And the defendant can then raise the counterclaim. And you can also have the proactive nullity action isolated. That would be covered by the central division. But, of course, there is also an option for a counterclaim for infringement. So that can be the reaction here of the patentee. So you can also get a combined situation here. So, of course, if you have any questions, just raise your hand. It's a lot of information, but I have to go through it to give you an idea before I come to the statistics. Here we have, that's the main thing that is a little bit problematic of the UPC. You have very short deadlines, and it's very hard, based on the case law we have so far, it's very hard to get an extension of term. So normally you have to stay within. So imagine you will get an infringement action, you're a small law firm, and you have only 3 months to do everything until you file your writ in defense. And that's very, very short term, because you have to inform your client, you have to discuss about which lawyers you use. If you're just a patent law firm, you have to look for a lawyer. And so this may be, and it turned out to be very short. And overall, as the statistics shows, the UPC courts managed to keep 1 year. That's what they had set at their target. They want to have set to reach a decision within 1 year. And that turned out quite realistic. So we have, in the average, I think we have between 12 and 15 months for an infringement case, which is very short, because it also covers validity. And that was a problem with the bifurcation before in Germany. You had the infringement decision after about 1.5 years, but the German patent court took about 3 years for the validity. And that was the so-called injunction gap. So the patentee could have got an injunction, and the defendant had to wait 3 years until he could do something. So that was a real problem, and that especially in preliminary injunction cases, because he was thrown out of market. So that is a good, but we have an interim procedure. This is quite helpful. So after the first written procedure, we have an interim procedure where the judge rapporteur discusses with the parties whether there's any option for settlement, and this is a specificity of the UPC, and then we have the final oral proceedings with decision. So what are some important issues of the UPC system? We have the unitary patent must be litigated in the UPC. There is no option to use national courts. That is important. If you decide to obtain a unitary patent for all the 18 countries, you have to use the UPC. And all your existing EP patents will be dealt with by the UPC unless you file an opt-out. That is the opt-out thing. And you can opt in again, so this is a strategy. It's called the withdrawal of the opt-out, but this is only possible once. And this is a good tool, so you can opt out to prevent central attacks on your bundle of patents. And if you decide to litigate, you can withdraw your opt-out and litigate via the UPC. This is a quite interesting option. That's why many European patents are opted out at present. I think about 600,000 are opted out. Now this no longer applies, the sunrise period is over, but as I said, you can always file the opt-out when you have a European patent or application, but you have to consider that as soon as someone sues you via the UPC, you can no longer opt out. So this blocks the opt-out. So as soon as a central proceeding has been initiated, you will be forced in. And as soon as a national proceeding says, if you're a global country and one of your branches has decided to use one of your European patents for national proceedings, you cannot opt in anymore. Okay, that's also one thing to consider. So it's clear we have to have a control of the litigation in a big company. So what are risks and opportunities of this new system? The main risk, that's why many people opt out, is the central attack. So if you have a bundle of say 10 validations, they can be destroyed with one attack via the central division if you don't opt out. So this is the invalidation. But you have annuity cost savings. If you usually validate in more than 4 countries or 4 or more, it is cheaper to use the unitary patent, and you have 18 countries covered with one European patent. You have to have the geographic portfolio management, as I just told you. This is a second risk that you have, because in the bundle system, you can decide based on your product portfolio, based on your activities on the market. You can decide, I don't use UK anymore or Switzerland. I focus on Germany. But this is no longer possible if you have the unitary patent, because the unitary patent is one patent, and you cannot skip countries of that. So this is a disadvantage you have. But you have the territorial scope is simplified validation and reduced renewal costs. You have a centralized litigation. This is the advantage for the patentee because you can litigate and can obtain decision remedies in all 18 states. And you can also facilitate your geographic license and assignment procedure. Okay, so now to the statistics. That's the situation at present. And as you can clearly see, we have many, many infringement actions, as we could expect. But luckily, these are not all NPEs. At the beginning, we thought, oh, all the NPEs will use this, the patent trolls, to put pressure on a small country, on the small and medium-sized companies. But this, at present, we have only about 15% or so that are NPEs. So it's not a real threat here. But we have, you see, the main focus is on infringement. And here you see how many counterclaims are filed. So it's about 60% are with counterclaim for validity and 40% without, or a bit more. That's interesting. Why don't the people attack validity? It's not really clear, but it might be that as a difference to other court systems, the validity counterattack costs money. It depends on the value of the case. It can be between 11 and 20,000 euro that you have to pay in an infringement case to attack validity of the patent, which is not the case in other court systems. In Germany, it's similar because we have the bifurcation, but in these joint court systems, that's not typical. And that might be a reason why we don't have so many counterattacks. And we have so far, so the provisional measures, provisional injunctions are readily available. The courts only require that you show that it's more likely that the patent is valid than not. So this is not a high hurdle. In Germany, it's much higher, the hurdle, if you want to have a preliminary injunction. So as soon as you would have an X document in the search report or so, you wouldn't get the preliminary injunction. So this is an advantage of using the UPC court. You will get readily preliminary injunctions. We had already about, you see, 50 cases, and 66% is positive. The outcome of about 66% were positive provisional measures. So it's quite good. And the infringement actions, we have about 60% of these were successful. And about 40% of the attacked patents were revoked. So this is also a good result. So it's not that it's more patents or it's more than 50%, but 60% patents have been upheld. Also, an interesting thing here is we have the infringement actions. This is how it developed. This is the first 4 months, the first 10 months, and the first 1.5 years nearly, and up to October. So here you see infringement has gone up. So the parties or the public recognize that this UPC system is good for infringement attacks, and you see that this can be shown here. It's very attractive for infringement cases here. Here you see, this is interesting, where you see how the local divisions are used, and we can see that about 85% of the infringement cases are done via German local divisions. The reason for that might be that Germany was always very popular. I don't know exactly why, but it was very popular, maybe due to the bifurcation, but we don't have the bifurcation anymore. Maybe the parties trust the German judges that they are doing a good work, maybe so. That's interesting, and what we also can see is that the number of national infringement cases went down. So we can say the infringement cases have just been shifted from Germany to the UPC court. That's what the figures show. So the main language is English, as we can see here. It used to be German, but now as German courts accept the English language as well, it has shifted more towards English now. And we don't have translation, and the UPC reacts faster if you file your writs in English. Here the EPC classes. You see physics, electronics is main thing here. And A is daily life, that's also to some extent pharmaceutical cases. So now I come to the end. I hope I have not spoken too long. I'm still in time. What are the lessons learned so far? So we have this course since 1.5 years. It's very interesting, and we can see that it's a successful start. And we can also see that the UPC judges follow the EPO-based decisions of the Board of Appeals. However, there are differences. A very important difference is that inventive step is judged differently. So the UPC does not apply the problem-solution approach. We know this, you define the closest prior art and then the object, and then you decide about. And the UPC does not use the approach of closest prior art. It rather selects the most successful prior art, which is different, or the most successful starting point. And even there was a case where a document that was not considered in an EPO examination was used as most promising prior art in the UPC case. So this is, you see, this can be tricky to go via the UPC because suddenly another prior art is used for judging your inventive step. It's very streamlined. As I said, we have very short deadlines, and the CMS, that's also a thing. You have to file everything electronically via the case management system on the website of the UPC, and this is very limited. So if you have special cases where you have a settlement and you want to acknowledge an action, it's very difficult to find the right work pattern there. So this is a bit still difficult, and considering the fact that you have to react in only 3 months, that might be a problem. So you have, if you decide to use the UPC code, you should familiarize yourself before you start actions to know what is possible in the system. So we can see that actually you would have to have a team of lawyers to successfully manage this all. We have good forum shopping options. That's one thing, because special national things are judged differently from one local division to another in another country. So you can imagine equivalence, for example. The question of equivalence is handled differently in Germany than in other countries. For example, The Hague just issued a decision where they have a full new set of questions regarding equivalence. In Germany, you might have heard about the cutting knife questions, these 3 questions. And The Hague would have a totally different approach. It's also about fairness and legal certainty, but different questions. So this is a good thing if you want to litigate and there is a question of equivalence, you can really check which local division would better fit your needs. One thing that came up also, it could be an alternative to US patent disputes, because we have 400 million people in these 18 member states, and there is no punitive damage. This can be an advantage or a disadvantage. The losing party bears all the costs. That's also an interesting issue. In the US, it's always very expensive to litigation, but here, if you win, you would pay nothing. And it's cheaper, of course, than US proceedings because we have no discovery. Oh, what's happened there? Do I have to press it? Okay, then as I said, we have the preliminary injunction, which is readily available. This is also one very good advantage, because in the US you might have heard about the eBay case. Preliminary injunctions are more difficult, but here there is no problem. The judges would just consider this degree of validity, nothing else. And of course you need a certain urgency. You can't wait 1 year and then ask for a preliminary injunction. So they have about 3 months is the typical period you can wait. As I said, it's a problem with medium-sized clients. One interesting aspect also is the definition of SME is different at the UPCA agreement. Normally it's called small and medium-sized clients. At the UPC it's called small and micro-sized clients. So it's much smaller, the entity which qualifies as SME before the UPC to get any cost reductions. But we have also seen Burford Capital, for example, there is litigation funding is available. We have no bifurcation. That's what I already said. And as you might have heard of this Angora cat thing that the judge, a British judge defined, it means that if you are in validity proceedings, the cat is very small, it's wet, and if you are in infringement, it's very broad. That's the scope of protection. So here, if you have no bifurcation, you don't have this option, which you typically had in Germany, for example. So this is one thing that's also a difference to be kept in mind. And important what has now become with the UPCA, with this agreement, is in Germany you can have a national patent plus the UPC, unitary patent, in parallel. With a bundle patent, it was not possible because as soon as you validated your EP patent in Germany, the German patent lost effect. But now you can have both. That makes it very interesting because you can select the bifurcated way in Germany or the common combined way via the UPC. That's like a new tool in your toolbox for litigation. That's, as I said already, we have this problem with the single judge. And we had even one case where the Munich local division said in the reasoning they were happy to find a technical expert in a biotech case. So to some extent, if you have a very complex case, it's questionable whether it makes sense to go via the UPC because you will have at least only one case, and that one judge, technical judge, he could be biased somehow. Because normally they don't accept any expert opinions. That's not very liked, especially by German local divisions. And that could be a problem if it's too complex. Might be better to go a national way. But I don't want to speak here in favor of national courts. That's just something to consider. And that's what, as I also said, my last point, the careful coordination is very important. If it's a global company with branches all over Europe or the world, you should always carefully coordinate between opt-out national actions and UPC actions. Because as you can see, as I said, you can be blocked if you do an opt-out, you cannot use the UPC, or if you initiate a national proceeding, you're also out of the UPC proceedings. So this is very important to have a coordination there. Okay, so that was all. It was a lot of information. I hope you still had a good insight. Thank you. If there's any question, we can also ask. You can ask later or now. Yes?
Business project located in European Union, UK. They launch the business. And they have official website where they published information about the project. European Union, UK. Most operating in this region. The company operating. After 3 years, some unethical competitor registered trademark for the brand, whatever was published in social media, in the web, in digital. Now, how the first business owner can protect the rights? Because we know, as per trademark law, if there are copyright with prior date, the trademark should be cancelled. Is it possible? Is it doable using the European system and UK system to prove that copyright was published?
For the prior art, it doesn't matter whether it's UK or not, because prior art is global. But
the question is, this business owner, can he cancel this unfair registration of trademark in UK and in European Union or not? Using the publish it in website with Google cache, with all confirmation. How? It's just your opinion.
This is no problem, because if you have if you can show that there is unfair This is separate. Of course, the UK is no longer EU member. It's two separate things. But in my view, this can be done, yes, for a trademark. So if you can show that it's an unfair. I don't know whether there's no domain, the CUDR, but you can go via arbitrary proceedings, also arbitration proceedings, to reach a settlement.
Okay. Thank you.
But otherwise, okay. Anything else? Any questions?
Olaf, we can do questions at the later half as well. Thank you. Thank you so much for the insightful presentation. We learned a lot from the UPC and how people can use it for their advantage as well. So, till the time we get the slides up, Olaf, I have a question for you. So you spoke about how the UPC is established and it's making life easier. Since we're talking about the virtual worlds, I have the question for you. How is Germany treating patents on virtual world? What's their stance?
Actually, there is no special thing. We deal as with software patents or computer implemented inventions. So we have these at the EPO. It's more regulated how the examiner has to have to judge the situation. In Germany, the examiners are more free. You have only one examiner, and we often have this case that the examiner just says that's no technical invention, it's just software. Okay. And you can say what you want. If he stays on this, you will get a rejection. And at the EPO, we have the clear guidelines. We can show here, look at this case, look at this case. And if we show that a technical problem is solved by technical means, we always get the first hurdle of technicity, of technical invention. So I would also, if you have a software on the borderline of business method or technique, I would always suggest go via the EPO. And I had a case, that was more or less a financial system, and it was drafted in the US, and they always used payment card and all these things, and the examiners right away say that's not technical, and you have little chance to go. And at the EPO, I would have more chances. I could say this is, but there is a technical problem, there's a technical means. So always think about if you have an application which is on the borderline of a technical invention, go via the EPO. It might cost a bit more, but you will get a patent in the end. And in most cases, not in Germany.
Okay, understood. Thanks for answering that. Are you ready? Or I can just go with another question. Okay. Yeah. So this question is to you, Sandjar. So since we're talking about metaverse and virtual worlds, and since you are an IP expert and been in this field for many years now, how do you decide jurisdictions in metaverse or IP related to metaverse? When there's a dispute happens, how do you decide the jurisdiction?
Yeah, thank you. 30 years I'm working in this industry, and last 5 years we understand that if we will know in depth to the digital and virtual, not understand how to properly handle things like this, so we cannot bring some additional benefit and revenue for the clients. And we checked very in depth what is the current regulations of the virtual assets. You know what is exciting? Maybe it's also some idea for your question, how to protect the business on the conceptual level, how to protect the method, not just technical devices. And we found that inside the copyright system, on the international framework under the Berne Convention, existing such new tools which giving to opportunity to protect the business concept itself, not touching to the technical device. It's very exciting. And the name of such protection is work of science. So now you have option to register your technology, your business concept as a work of science. What's interesting, it will be protected immediately in 181 countries of the world within just 20 days. If you try to get similar in patent, to cover 181 countries, you know how many years you will spend and how many rejections you will receive. This idea that implement protection of virtual assets is available, and by the way, the registration authority, it's not government, it's private, but very strong, also located in Germany. It's called Interlocal Copyright Office. We're working very close. They created very high qualified expertise how to check such kind of items for the uniqueness, for the protectability, because copyright office usually not checking, but they're checking. And this create to us legal tool really how to protect virtual assets and digital assets. And second, regarding the brand, since after registration, today without understanding how to protect technology, tech, IT things, you will like behind the train.
Right.
All industry, banking, car, all going to AI to tech. Now we as experts, patent attorney, lawyers understand how to protect. This is a very challenging task, and we found this way through the copyright, to the modern copyright protection. What is the modern copyright protection? Means the copyright before registration should be validated, check for the uniqueness, check for the protectability. Today existing 20,000 copyright office. Most of the offices are registered by notification. Whatever you apply, they register. They not conduct all the searches and other things. But there are 3 copyright offices who are doing this. In Germany, one of them. So if you understand how to make protection under modern copyright, it's an opportunity. Why? Because digital and metaverse not existing without internet.
True.
True? Maybe some internal you can do, but in globally without internet not existing. It means that if you want to protect your rights, you should interact with internet operators. Who is the main internet operators? Shortly, just your pitch, just 2 minutes, yes? There are internet, Google, Facebook, all. Well, what is common between all these main operators? They're United States based. That's the reason you should understand how working United States law. Even after registration in European, if you go to internet, you should touch the United States law. And in US law, we have one main law, DMCA, Digital Millennium Copyright Act. In this law is mentioned that United States recognize only if your work protected under copyright office. That's it. No patent, no trademark. Please keep it in mind. That's the reason why we start thinking what is copyright existing new. We found the way, and we're ready to share this knowledge. This is my answer for you.
Interesting. So I just have one follow-up question. Because you spoke about work of science,
yes.
So business concepts as to be registered
yes.
under Berne
yes.
Convention as
yes.
work
yes.
of science. This is something interesting. So how can you enforce this in the digital world?
So we have many successful cases. So with Sandjar Group, 250 people working in our network. We have 45,000 clients within 30 years. We have at least 5 successful cases when, based on protection as a work of science, we removed unfair competitor who makes the replicas of the business concept in mobile application. It was
in the digital world.
In digital world. It was for the delivery service. It was a payment solution. This was exciting. We proved this work of science is valid. What is the biggest problem with the work of science? On national level, no one understands what is it. No one. You can go to any trademark copyright office here in Dubai Department or US. Ask them, okay, this is a Berne Convention, this work of science. Okay, internationally it's allowed. Our country joins the Berne Convention. I want to register work of science in the country. UK, Germany, Emirates, they don't know how to register. Because to register, they should conduct analysis for uniqueness. How local copyright office can check unique copyright work? It's very expensive. You should check 20,000 databases. Because copyright not integrated like patent trademark. It's separate. 20,000. And we found one company, by the way, it's very interesting. Also, look at in Germany. The name is, I think, Scan Bureau.
Okay.
They provide the searches for the courts. And for the big 3,000 biggest corporations, they provide the searches. They have integrated search for all copyright. With universities, copyright of very high sophisticated, high level search. This means mostly voluntary research, but when you apply work of science with such kind of protection, this is strongest, this is really working. What is the main difference between registration, your technology under invention patent, and work of science copyright? For patent, you should prove certain points, paragraph, formula. For work of science, you should find 3 closest analogs and prove that there exists. It's like mostly for the scientific work. You know, when you make your degree scientific, you should find 3 works, proves them most similar and shows a difference from them.
Okay.
This work of science, this innovation, very few lawyers, because we are working on global level. I know if maybe 20 people from whole IP industry know how to register, it will be good. But it's new. And second problem is that mostly United States lawyers, they don't like work of science because it's breaking the revenue. If you can register technology, one IP certificate, 20 days registration, covering 181 countries.
All right.
For lawyers, it's not interesting to sell such exciting solutions because they want to be honest. We have long time battle with US lawyers. They're trying to push, go to patent, go register globally, and country by country, category by category, they generate revenue. But for businessmen, it's not interesting. Because if you want to protect in internet, only copyright, as per DMCA law. That's it. Or patent, trademark, useless absolutely if you want to protect in digital. It's very complicated.
Understood. Thanks for sharing that. Let's hear Avinav about the virtual world, and then I'll come back to you with a couple of more questions as well on the digital world. Thank you.
Good morning, everyone. I'm Avinav from Airbus, India. I'm, based out of Bangalore, and I'm from the IP Analytics and Intelligence team. Just one thing before we begin, my friend Prayank just said I'll be talking about what Airbus is doing. There's only so much I can tell you what Airbus is doing, but what I'll be telling you is in general where the industry is heading to and what are the different things which are emerging and what are the challenges there. Now the challenges I'm going to be talking about, the solutions are found in probably what Olaf has said, and what we all have discussed so far, but then the thing is it's all very vague at this point in time, and probably as time comes we'll get better solutions, because as you'll see, the current regimes of protecting your intellectual property are based on what we call as instruments like patent or a trademark or something, which means only when some infringement has happened you bring that into effect, right? Now the problem here is where we are heading to with Metaverse and all this, cost and time being one thing. The other thing is what we need is your IP to be protected in real time, right? So the legal aspect as well as technically it needs to be protected in real time. That's a solution where people have been working on, but it's not, really concrete right now. Again, it's an emerging area. We can talk about it. But yeah, what I will be talking about today is Metaverse, but Metaverse, not Zuckerberg's Metaverse, it's an industrial Metaverse, right? So the industrial Metaverse is different slightly, or if not a lot, from the consumer Metaverse, because the consumer Metaverse is based on your avatars and you're talking with people and interacting and this and that. But in our, the industrial Metaverse, we have real-time hard problems, and these hard problems need to be, these might be very critical, safety-critical problems, and these problems need to be addressed and executed via different solutions in real time. And these solutions also are running across different silos in a particular company, and if not just the company, amongst the company's vendors, the suppliers, the the service providers. So you have different platforms working together in real time, in sync, with a single source of truth, right? That's what the industrial Metaverse is about. I'll get to that. So before we begin, I just want you to take a quick look at this slide. So what this slide basically tells you is, it tells you about a concept of digital thread and a concept of a digital twin. Now, what is a digital twin? A digital twin is just think of it as a digital avatar of a physical asset. So if you have an aircraft engine, you have a digital model of that aircraft engine, and this is not like, the conventional static models, all right? These are running in real time, and what's interesting is it will take the information of the physical twin, which means if an aircraft is in the air, the operational information that the aircraft is collecting is in real time or in near real time sent to its digital model, digital twin, and then the twin takes that information and runs further different analytics like prognostics, which means your aircraft, the physical twin might not know when engine maintenance is required, but its digital twin knows that, okay, I only have, say, X 100 hours left, and a service needs to be scheduled very quickly, or some upcoming problem is coming. So the digital twin is smarter than the physical twin, all right? And you can have digital twin for different reasons. A digital twin just does not mean that it needs to be a physical system. It can be a process. It can be a process in your production flow. So if you have some bottlenecks coming up, it can even be integrated across organizations. For example, if one of your suppliers has some problem sourcing something, that fact is, brought into your systems, and then your systems show you the digital twin of your manufacturing line is going to reflect. So what do? You can use that to basically optimize things, right? So this is what we are talking about. And this ideally, all of this should happen in real time or near real time, depending on the criticality, all right? So it's very different from, as you can see, the consumer metaverse, right? So also one more thing is, you see the single source of truth, this blockchain now. The digital twin is going to be working on data from the physical twin, as well as all the, like the hybrid models and the physical models, whatever it is that you model it on. All right, now the thing is, it's going to run on information. Now this information is coming from something called as the digital thread, right? So the backbone of your digital twin is going to be a digital thread, which is running across different systems throughout your organization. And if you make a single change in, one of these silos, it should be able to be, exhibited, and its effects can be exhibited in your model in real time. So this is very important because, coming from an industry where, safety and certification are of utmost importance, right? For us, everything needs to be certified, right? Whether it's Boeing or Airbus. And, small things make a huge change, make a huge impact. And these might be very costly impact in terms of money and time, but it can also be safety, right? So everything needs to be traced back to every nut and bolt. So we are very serious about this, and this is where things like the digital thread and digital twin come in. So it's very important for us. Also in the automotive industry, they are using it, but how they are using it and how we use it, there's a slight difference because let's, bare bones. If something happens to a car, maybe 4 people go down. If something happens to an aircraft, 200 people minimum go down. So the level of safety, criticality, all these things dictate how we implement these technologies in our industries, right? So, what this digital thread basically means is a single source of truth. So if one engineer changes something, someone in the manufacturing line sees the same change in real time, updated, all right? How it works, we can talk about it a bit later, but this is what it is. This is the ultimate digitalization dream for the OEM industry, all right? And also what happens is, as your physical twin is working, right, all the data which is basically thrown into the digital twin from the physical twin, this is also used for, operational impact, but also it can be used in, a more upstream in activity, like helping to improve the design of your product. So if I know my product is not working in, say, freezing conditions or very hot conditions, what do? Right? I can actually use this kind of information to improve the next version of my product. So this is also where it's coming up, all right, in terms of importance. So basically, what runs this whole show is data, right? So now we'll come to data. Now, you have to understand one thing. In our industry, data is gold, and data belongs to different people in an aircraft, all right? It's not the airframer only, because the engine data is actually used by the engine manufacturers. They have control over that. There's so much only that we can use that data to provide services or internally use it to improve our product, okay? They own that. So similarly, we airframers also own data, which is used internally or to provide services, all right? Just an example, an average A350, our aircraft, produces up to 400 parameters of data, right? So what do you do with so much data? It all makes sense, but you need to know how to collect it, how to use it, and in what context. Similarly, Boeing 737 generates at least 20 terabytes of engine data every single hour. So that's a lot of data. What do you do with it? This is gold. You just can't chuck it away. You have to make sense of it. How do you do that? That's our challenge. See, metaverse and all is a very glamorous topic to talk about, but I am talking about something very hard. I'm talking about how you take data, how you make sense of it, and how you implement it in such a way that you actually can have a meaningful thing called metaverse, all right? And also, our metaverse is actually a combination of industrial metaverse and consumer metaverse. As you can see in this slide, you can actually use the metaverse across different use cases in these value chains, right? Now, what we need to understand is the metaverse will actually be a network of thousands and millions of digital twins, right? So if I talk about a metaverse for a single engine, there can be a metaverse because in that engine you have the suppliers reading into it, you have the airline reading into it, you have the airframer reading into it, you have the services guy reading into it, right? So that's the small little metaverse of that engine. And they can interact with each other, do whatever it is. Similarly, that engine goes into an aircraft. You can have one for the aircraft. Context is very important here. It's not one big monolithic system. This needs to be connected to the aircraft. Now you need to know if there's changes in the engine, how it impacts the aircraft. So the aircraft metaverse is connected to the engine metaverse, right? Now also, one more thing. For the aircraft, you can have n different digital twins for n different people. Similarly for the engine, right? For the engine, you can have one for the engine manufacturer, one for the services. The services guy does not see what the manufacturer sees. The manufacturer does not see what the airliner sees. It's all protected, but then at the same time, contextualized and shown in the correct light. The same thing, but in different light, right? This is very important. How do we do it, right? So without taking much time, all I want to say is, as you have seen, it actually begins with data, who owns it, how it can be protected. Then it goes on to things like digital twin and digital thread, which runs on the data, right? Now these digital twin models are going to be shared across different people, across the company as well as outside the company, and even maybe with the regulatory authorities, right? So how do you make sense of, how do you protect your IP there, especially when you're sharing your digital twin models with your vendor and your suppliers who might be working for your competitor maybe, right? What we are now in the process of using things like blockchain, couple it up with digital twin, digital thread. AI happens to be a tool in the chain, right? So it's given that everyone is going to be using AI. So that's not the big deal here. It's how good your AI systems are. And your AI systems are only as good as how you train them and on what data you train them, the quality of data. Trust me, there are hundreds of patterns you'll see today which are pertaining to industrial patterns, which are pertaining to how you synthesize data to train your neural models, right? So that's where we are at. This is the hardcore part. It's nice to talk about metaverse and this and that. What is metaverse? For me today, like I just discussed, we can all be working and talking about the same model in different contexts. I can be making some changes in the model. You will not see it because you're maybe a service provider outside or something. But whatever needs to be shown to you, based on whatever changes I have made, that is shown to you in real time. That is our industrial metaverse. So, and like I said, the current tools for protecting IP, it's all based on once infringement happens, then what do you do? You use this, you use that. But what we are looking at is probably something like DRM tools to lock out things. There are a lot of patterns you can see which talks about sharing data over using a digital twin and masking information for different stakeholders, things like that, right? So that's what the current industry is actually struggling with and trying to build on. So yeah, we can discuss. That's all. If you have questions, you can ask me.
Thank you. For the insightful presentation on digital twin and metaverse. Sandjar, I would like to come back again to you to understand. So we spoke about multiple virtual worlds being in metaverse and how work of science can be registered. Now tell me, if I am a brand and I am into, let's say, gaming, or I have a gaming platform in one of the virtual world, my trademarks would be restricted to that particular virtual world and the use case and the trademark classes which currently are governing those registration. How about somebody using the same name, same branding in some another virtual world, perhaps for the same or the different activities? Oh, can 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 that other person own the same name, but in different virtual world? Is that possible?
Yes, we should understand one thing. Trademark was created as a part of industrial law, like patent.
Mm-hmm.
And all trademarks, they're touching any country, any region. The problem is with digital metaverses, this is another world. And very difficult if you have a trademark, to protect this trademark in virtual air, almost not possible. United States governments, they faced this problem in 1998. So many years ago, they understand that digital industry is absolutely nothing. It's not industrial property. But till now, we don't have digital law. We have industrial law, we have copyright law, we have commercial law. It's good. But for digital law, we don't have it. It's not existing. This is a huge challenge for all entrepreneurs.
Mm-hmm.
That's the reason, if you have a trademark, maximum what you can do, you can find the domain owner of this metaverse, go to register authority of this domain, and try to block domain and block hosting. But to protect fully with trademark is useless. It's very, very sorry. People paying for trademark, they're thinking that trademark protection will help in digital virtual world, but it's not working. That's the reason. But for any challenges, business finds solution. We found solution. For trademark, we also found alternative in the copyright. Why we are touching the copyright? Because we want to implement Digital Millennium Copyright Act for United States to prove to the Google, to prove to the YouTube, to Facebook that we have copyright registration as per DMCA law, and after this, all these big internet operators, they should recognize. Which solution we find for the brand? Mm-hmm. Also, this another new tool, composite copyright work.
Okay.
This work also on the international level it's existing, but on local level, sometimes you should make implementation. What's in composite copyright work? Why composite? Because it consists of two parts. Verbal, part of domain. Visual, definitely we should connect to the picture, because copyright itself directly not protects the name. Mm-hmm. You can protect the name as part, like title of the whole work. That's the reason we need a logo. Brand name, brand logo, and domain. If you combine all three elements and apply for registration and composite copyright work, in this way, this copyright certificate will give the opportunity to protect your rights in virtual and digital world. This is how we find the solution and how we're selling. Alhamdulillah, it's working, really working. We're blocking, we're protecting many companies. One of the biggest CIDUS metaverse with 20 planets, is 100,000 users. They use this success strategy without any patent, without any trademark, only using modern copyright registration. They protected brand within 10 days all around the world. Can you imagine protection brand 10 days all around the world? Exciting.
Very good.
And technology within 20 days. They process protection of the rights and fundraising $180 million. They make fundraising due to strong protection. Because if you cannot protect, anyone can replicate, the price will go down. The valuation higher if it's stronger.
Right.
And here is the problem with patent. To provide properly international protection based on patent, you should go so many countries, so many registrations. It's a headache. But another tools existing.
So composite copyright registration you seek from the USPTO, or you apply
No,
in
no,
UAE?
we are not touching patent.
Or you go to WTO for that?
No. We're using the Berne Convention. There are 26 international treaties and agreements in IP. We're not touching patent. It's it's useless. You know the case with Microsoft, Edison, all this, it's not working. They're all trying to connect to some physical. But metaverse don't care about physical device, about service.
Right.
So we're using only copyright on global level. And as I said, one of the best registration organization, yes, it's commercial, but it provides proper validation, search, other things, located in Germany. As I said, it's a very small copyright office, but they're doing exciting registration. We're very happy that we found such kind of, it's very funny things. When we start looking for the proper validated copyright protection, I have my friend from Uzbekistan, I'm originally from Uzbekistan. He has big farm with many lamps and cows. His name is Tursun, just small, it's real case. We tried which copyright office makes the preliminary search. So we applied to UK copies, we took the Shakespeare, put his name, Tursunbay, and apply. And they registered beautiful that he is owner. We applied for United States Copyright Office, the Lincoln work, they registered. We applied to the India, Mahatma Gandhi, they registered that he is owner, he author. Okay. No one checked. We applied for China, Xi Jinping, his work. We applied to Russia, Pushkin, they registered. All it means no one checking, not. When we applied to the Germany for the Goethe, you know Goethe, German? Goethe is one of the main points. And they rejected to us. No, we conduct the search, it's not your work, you're not author. All other registered automatically. The most famous work we put from this country applies registered. In his wall, he has more than 20 certificates, very beautiful, those steps, all famous work all around the world. He was recognized by official authority as an author. This means no one checked. German checked. German quality is still working. That's the reason why we communicate with them.
Excellent, excellent. Thanks, Sandjar, for sharing your thoughts on this point. So, all in all, I mean, we learned from Olaf about the UPC system and how European and German courts have now doing the prosecution as well as providing the opportunity to do a litigation in a centralized manner, reducing timelines and the cost for everybody. Good to know about that. Avinav shared how Airbus is using digital twins and metaverse technologies in tandem to improve their efficiency, to ensure the safeties are not compromised, and any real-time change in the hardware world is also reflected in the metaverse world, so that the safeties are not compromised and the innovations are captured in real time, which is something which is going to be a challenge to enforce in the future as well. And from Sandjar, since he's an IP expert in the virtual asset and regulatory authority related work, we got to know two important things. I mean, these are the takeaways for me as well, is to register, is to rely on Berne Convention and the new modern copyright laws, for example, work of science, for seeking registration in the metaverse and the virtual world, rather than just relying on the industrial rights like patents or trademarks or copyrights. And also to have combined copyright registration, which will club your name, your brand, your logo, as well as domain. All three things put together to give you the holistic protection in this virtual world, because trademarks will not help you in that particular things. And yeah, that's pretty much the learning for me as a moderator. And I'm really glad to have such an esteemed panel here, and thank you so much, all of us, for joining us for the discussion.
Maybe just last idea.
Yeah, sure.
If you ask today your clients, almost all here is lawyers, patent attorneys, correct? We are like professionals, yes. It's our network. If you ask what is the main money generating unit, assets, equipment by your customer today, it's not manufacturing, it's not building, it's not. This is social media, very simple, which generate revenue for your clients. Social media. Yeah. Now, how many clients protected your social media as a IP and put to the company as intangible assets? No one. But today, existing opportunity, you can make today your business account in Instagram, you can make your IP as intangible assets. This is doable, but they don't know. If we, as an expert, we don't know how to do it, how we can support to our clients. Please keep in mind that all what existing websites, social media accounts, corporate, mobile applications, but especially social media, people think it belongs to Instagram or it belongs to YouTube. How can I make this profile as my business? Very challenging task.
All right.
But I'm just give to insight that it's doable. We're ready to share the knowledges because we in my company, even the keywords was Google capitalized $1.5 million in my company balance sheet. Mm. Because these assets, this real work of mental activity of my team, why I cannot? And how to calculate the value? Very simple. You can convert your salary to intangible assets. You're paying salary. Where anyone paying the salary, you have two options how to record in balance sheet. You can record as old school as expenses, or as investments in intangible assets. Investment in the customer list, in the brand, other thing, which was created by your team to pay salary. This will, it's exciting. You will return your money in front of tangible assets, increase the capital, and this capital we're using here in UAE to receive bank loans using as a mortgage. UAE created exciting opportunity. People don't know how to utilize. This is biggest challenges because it's very difficult, very expensive to make money in Dubai, but you can make back money in those intangible assets. It's doable. Just some insights.
I think I need to continue the discussion offline on this since the topic is a bit different than what we are supposed to discuss here. But yes, thanks for touching on that thread as well. So yes, thank you so much everybody for being a patient audience, and I think we are all about the time as well. Thanks IIPLA for providing us this opportunity to share our insights. Thank you.
So, do we have any questions from audience? Okay, no questions. So, thank you all the panel members as well as the moderator to join us. So, now I would like to request the moderator Prayank to please honor the panel members. For Avinav Banerjee. For Olaf. Please, and I would like to thank Prayank for his cooperation. This is for you. Thank you so much. So please join us for the group photo. Thank you so much, everyone. Thank you.